busy. Anyways, any questions? Yes.
I'm speaking on behalf of a couple of people that are here in the audience right now. They've joined the Atlantic.
Property standards?
Yes.
Okay.
They have been approached by bylaw enforcement of Bedford Township about material on the property which they're using for building, repairing their roof, new shingles, and some vehicles that he repairs for sale. People granted, he repairs it, they go away. He buys vehicles for repair and for sale on it. They've been suggested to them that bylaw be allowed on the property to look at the things and maybe negotiate, find a way around bylaw, and they're concerned that whether they should or should not allow bylaw enforcement onto the property. They've applied for the patent grant just in the last week or so. So if you could maybe expand on that, maybe allay some of the fears that they have around the situation.
So lately I've been delving into the Heritage Act. And you're going, what does that have to do with what he just said? Anyways, under Part 5 of the Heritage Act, there's Section 45 and 45.1. Now, Section 45 tells the municipalities before they can designate property, they must either purchase, enter into agreements, lease or expropriate, or under these agreements enter into an easement or a covenant. Then 45.1 says property standards bylaws. So 45 and 45.1 are connected, meaning that the municipality must own it or have entered into an agreement before they can implement property standards bylaws under 15.1 to 15.8 of the building code. We also know now that the municipalities under Section 11, subsection 2, Section 4 of subsection 2 may pass bylaws for the assets of the municipality to exercise its authority under the Municipal Act or any other act. Well, near as I can figure, the building code is another act. So unless they are creating property standards bylaws for an asset of the municipality, I don't know how they possibly can be telling these people that they have to clean up their yard. Now, under the original Baldwin Act of 1849, if you had a messy yard, the municipality did have an avenue to go down. They could put up a very high fence on municipal property and a gate so no one would have to look at it. But on the other hand, we've already had a court case in Georgian Bluffs that's identical to this. A fellow named Jim Moyer has 100 acres. And Jim Moyer liked to collect old cars and buses and so on and so forth. You know what kind of property I'm referring to. And that was Jim's hobby. And they sat out in his yard. So bylaw came along and they told Jim, well, Jim, you got to put up a fence. So Jim went around to all the local businesses and he got their used skids. And he stacked them on top of each other to create this privacy fence. Well, bylaw didn't appreciate Jim's fence. So not only did they take Jim's fence, but they also took a whole bunch of Jim's old vehicles to the wrecking yard. Jim is a much richer man now. And on top of that, though, they added the cleanup costs onto his property taxes. So Jim sued them. And Jim sued them the first time, and they weren't going to give him his costs, and they were only going to remove the levy on his property taxes. He appealed that. And Jim won $52,000 plus his legals, plus the cost was removed from his property taxes. But these are the statements that I like the best. The bylaw inspector is to know and understand the limitations of his legal authority. In other words, you can't just go and do things like that or tell people that they have to clean up their yards. and that the township had actually committed a trespass by allowing all of this to happen, because they had a property standards bylaw. So in other words, if they try to force these folks to clean up their yard, their lawyer might look into getting a copy of the lawyer's case, but it's entirely up to them, and it's up to their lawyer. It's not for me to say, but I know what I would do. Been there and done that before. So, anybody else? Yes, Tim?
I guess within the press a month ago or so, there was some concern about the claims that the natives were having in Ontario. I know there's a lot of hunters and fishers who are concerned about losing traditional hunting grounds. How does that play with the Land Grant Act?
Okay, so you're going back to the Royal Proclamation of 1763. And the Royal Proclamation of 1763 was basically referred to as the Magna Carta for the Native community. And if you actually look at section 25 of Trudeau's Constitution, it refers to the Royal Proclamation of 1763. And how that worked was that this is when you had your Native commissioners, and they would have to purchase the land from the natives, and then it could be granted to the settler. Now, there is that section, that map that goes with that. Then there are the various other treaties. But then there's also the situation with the Hudson Bay Company, because the Hudson Bay Company was created in 1670. But it was expanded, I think it was 4 times. So by the time the Hudson Bay Company was no longer in existence, it covered the majority of northern Ontario up and around through northern Quebec, right around the Hudson Bay area. So that is another, and actually it came quite a ways down. So that is another option for people to look into. They have to look into the treaties, which is not easy because there are a lot of them. I read one treaty. Did you guys know that the city of, Brantford was originally only 19 square acres? And I think that was treaty number 2. But that's the whole thing. And the thing is, so the federal government, this is where everything went sideways. The federal government is supposed to have control over the native lands and the Indian affairs, right? Well, in 1881, there was a court case, and it was called the Parsons case. And it completely bastardized our Constitution because there was political interference at the Privy Council in England. So what happened with the Parsons case was the Privy Council actually allowed the provincial government to interfere in an insurance contract. The province was never to have that authority. When people talk to you, when you're talking about constitutional things, and some of these, particularly the Ministry of Natural Resources, will say, well, the province has control over all property and all civil rights and everything nearly local and private in nature in the province. And they'll say it's section 92, subsection 13, and 92, subsection 16 of the British North America Act. That is not true.